Good afternoon, everyone, and thank you for tuning in. My name is Michelle Sonin. I am the head Northeast Asia at SIAC. On behalf of SIAC, I am delighted to welcome you to the second SIAC Japan webinar. Today's webinar aims to provide a practical guide to arbitrating intellectual property disputes. IP arbitration is on the rise, and in recent years, we've seen at SIAC an upward trend in the number of IP disputes. In Japan and other tech hubs worldwide, IP arbitration has become a topic of increased interest recently. Our speakers today include both arbitration experts and IP specialists, and I am thrilled to hear their insights on IP arbitration. SIAC has a specialist panel of arbitrators for intellectual property disputes, and three of our panelists today, Mr. Hiroyuki Tezuka, Mr. Brian Gauss, and Dr. Stanley Lai. These three panelists are members of the IP panel. Dr. Lai is also the chairman of the Intellectual Property Office of Singapore. Thank you all to all the speakers for joining us today and sharing your expertise. Before we begin, I would just like to draw your attention briefly to the Q&A button at the bottom of your screen. Please use that to submit questions to the panel, and our speakers will try to answer as many of your questions as possible at the end of the session. I also note that today's webinar is being recorded, and it will be posted on the SIAC YouTube page shortly. Without further ado, I will now hand the floor over to our moderator, Mr. Tony Andriotis, partner at Quinn Emanuel, Urquhart & Sullivan, and based in Tokyo. Thank you, Tony, and have a great session, everyone.
Thank you very much, Michelle, and thank you to SIAC for giving us this wonderful platform. This is really fantastic. I wanted to thank all the panelists for being here, and I wanted to thank all the attendees for logging in. I think the entire world is going through some very interesting times right now. So that you've taken time out of your hectic schedules to log in is very much appreciated. It's an honor for me to be here with such an esteemed panel. As Michelle said, my name is Tony Andriotis. I am a partner with Quinn Emanuel, Urquhart & Sullivan. I am also a board member of the Japan Association of Arbitrators, the JAA. I am a advisory member to the JIDRC, which is newly formed here in Japan. And I'm also a professional and institutional relations officer for the JCA, which is Japan's native arbitration institution. I also happen to be the president of the Greek Chamber of Commerce in Japan, but we'll put that off to the side. As I mentioned earlier, it's an honor for me to be here, and it's an honor for me to introduce the panelists. What I'd like to do is ask the panelists to just briefly give us a bio of who they are and why they're on the panel, because I think they know themselves far better than I know them. I'd like to start with Mr. Brian Gauss. Please, Brian.
Thank you, Tony. First, I'd like to thank SIAC and Michelle for inviting me. So my years in practice has been long, but my resume is short, and you will see why. Because I've spent 20 years in practice and 15 years in-house, so a total of 35 years, at first Microsoft, and actually first IBM followed by Microsoft. And I've really been interested in technology and the IP aspects of technology. And right now, my practice is basically acting as counsel and as arbitrator in most disputes involving technology clients. And obviously, matters coming to me tend to revolve around those issues. Most often, there is an IP element involved, even if it's a purely contractual dispute. And so far, so good.
Thank you very much, Brian. I would like to now move on to Mr. Hiroyuki Tezuka.
Hi, good afternoon, good evening, or good morning, everybody. My name is Hiroyuki Tezuka. I'm a partner of Tokyo-based law firm Nishimura & Asahi, and I'm currently serving as a court member of SIAC, as well as the chair of the SIAC Japan Users Council. And I'm also an executive director of the JAA, Japan Association of Arbitrators. And I have been involved in a number of arbitration during my almost 35 years life as a lawyer, and among which I have been involved in various interesting IP-related arbitration involving technology patents, joint development, software disputes, copyright disputes, gaming software. I hope that the participants can enjoy today's session. Thank you.
Thank you very much, Hiroyuki. I want to move on now to Mr. Kevin Kim. The microphone is yours, sir.
Thank you, Tony. My name is Kevin Kim. I'm senior partner at the Pitt & Kim, this arbitration boutique. I've been a lawyer for about 33 years. I did various work, and I'm now doing the international arbitration only. I have a position in ICCA Vice President, and KCAV, the Chairman of International Committee. And also I'm acting as an arbitrator in JCAA, Users Council in the SIAC. I'm doing more counsel work. While I'm doing as counsel work, I did a number of IP dispute involving patents, lots of cases of copyright, and design development, and in an auto part, or I especially did a lot of cases on the online computer game cases. There's more than 7 cases in SIAC and ICC and JCAA. So I hope you can enjoy this exercise. Thank you.
Thank you very much, Kevin. And I'd like to turn to Dr. Stanley Lai. Please, sir.
Thanks very much, Tony, and thank you very much, SIAC, for the very kind invitation to speak on this panel. And I'm particularly, impressed and also humbled by the quality of my fellow panel members and panelists. Thank you so much. I had the IP practice in the firm of Allen & Gladhill, Singapore's largest firm. I'm also a commercial litigator. I do work in commercial disputes, insolvency, restructuring, together with a staple of intellectual property work. I have an active court practice in IP in particular, and I've argued cases in the High Court, Court of Appeal, and also the Singapore International Commercial Court. In terms of my arbitration experience, I do sit as arbitrator from time to time. I've also appeared, and more frequently I appear as counsel in arbitration. I have encountered information technology and IP disputes in the course of my work. I'm happy to share my perspectives. Also, I was involved with the committee that was set up between the Ministry of Law and the courts to look into the whole area of IP dispute resolution. And many of the that were undertaken a few years ago through that report, which I think reported in 2016, 2017, very much culminated in what we see today to be the Intellectual Property Dispute Resolution Act, which was passed last year. And that, I'll say something a bit more about that later on. Elsewhere, I think Michelle already very kindly introduced me as a panel member on the SIAC IP panel. I'm also the current chairman of the Intellectual Property Office of Singapore. I've been 10 years in as a senior counsel before the Singapore courts. In 1995 to 1999, I finished my doctorate in computer software copyright, culminating in a book that was published in the year 2000 by Hart. So thanks. I think that's pretty much me.
Okay, thank you very much, Stanley. And just for the audience, we're going to stay very casual for this panel and go by first name. So my apologies to the panelists, and just wanted to give the audience a heads up. First, just to frame things, when we talk about IP and ADR, as Michelle said, there has been an increase in the use of ADR instruments such as arbitration when dealing with IP. But when we talk about IP, we're discussing several different things. We're talking about, for example, copyrights, trademarks, and patent law. When we're talking about ADR, we're also talking about what's becoming very popular right now, which is URL disputes. URL disputes are more and more being handled through ADR institutions, sometimes being handled without even meeting, just completely online. But when we're discussing the patent area, the one issue we're dealing with is the fact that patents tend to have a certain sovereign monopoly aspect to them. State by state, country by country, they have their own rules on how you register patent and how you protect patents. So this gives us an issue when we're dealing with an ADR. If you have an award from a tribunal, for example, in arbitration, how can they compel a sovereign to change their patent laws? So this is one thing to consider. And when we see patents, where we're really seeing it take off in ADR is when we're dealing with contractual type patents, such as standard essential patents. So for example, if we have the DVD standard or the Blu-ray standard, you have a pool of institutions that contribute aspects of that patent, and they all own a piece of it. We're seeing more and more of the disputes dealing with these kind of standard essential patents being handled by arbitration. And the panels will explain why that is, and what are the unique aspects of ADR throughout today's panel. So with that frame, I'd like to start by asking Hiroyuki a question, because this is about even though we're dealing with a general overview on patents, this is still a Japan-specific panel. So Hiroyuki, if you could tell me some information about the status of patents in Japan, be it the court system or how it's working with ADR, and any changes specifically that have been happening in Japan in regards to arbitration patents over the last decade or so. That would be greatly appreciated. Please, Hiroyuki.
Yeah, thank you, Tony. So I would start with the overview of the arbitration on patent disputes in Japan, followed by a brief observations as to the arbitration on SEP, standard essential patents. And a large number of patent cases are still litigated in courts, as disputes may arise with a contract. And the Japanese government has taken steps towards so-called pro-patent system, introducing amendments to make the proof of damages easier, a wider document and other evidence gathering, recently introducing a so-called court-appointed inspector who makes the on-site inspection of the defendant's facility. And also they established the IP High Court so that the cases will be handled by judges with sufficient expertise. And on the other hand, there are also contractual disputes between patents arising from license agreements, joint development agreements, patent pool agreements, etc., which may contain arbitration clauses. The issues involved there may include whether or not the respondent products are within the scope of the licensed technology, giving rise to the royalty payment, or whether the patents should be jointly owned as jointly developed technology, or should it belong to the party who has allegedly invented the technology independently. But there are cases where the validity of patents is an issue. But interestingly enough, whether or not the validity of patents can be decided by the arbitral tribunal may itself be an issue, since in some jurisdictions, the validity may be decided only in a separate legal proceedings for invalidation, where the patent agency is a party. And the Japanese system used to be the German style, where the court in infringement case could not decide on the validity of the patent. Defendant must fight against the Japanese Patent Office in the patent invalidation proceedings. The idea behind this is that the validity of patents which grant the patent holder a monopoly of the patented technology for a certain period of time in exchange for making the technology openly known to the public is a matter of public concern. But Supreme Court judgment in the so-called Kilby case in 2000, April, changed the situation. It says the court in infringement action can decide, quote, whether or not there obviously exists sufficient grounds to invalidate the patent, unquote. And if the answer is yes, then the exercise of patent rights would not be allowed as an abuse of rights. And then the Patent Act of Japan was amended in 2004, and so-called defense of patent invalidity was explicitly introduced in Article 104 and 3, paragraph 1. It essentially said that where the court finds that the patent should be invalidated by a trial for patent invalidation, the rights of the patentee may not be exercised against the adverse party. So here, the obviousness requirement element required in the Kilby case is no longer necessary. The invalidity of patent in the context of patent infringement litigation will only have legal effect as between the parties to such litigation. And I understand that in the United States, once the patent is found invalid in an infringement action, it's dead. So now we can safely say that the arbitral tribunal may decide on the validity of the Japanese patent where that is an issue in arbitration. But since the patents are granted by each jurisdiction, you may need to consider if the arbitral tribunal seated in Japan may decide on the validity of the patent issued in other jurisdictions where courts in infringement action may not decide on the validity. And where the IP dispute involves copyrights, such as computer software, gaming programs, which arise without registration, perhaps the governing law of the contract may matter, but I won't go further on this point now. And my second point is arbitration of SEP standard essential patents. There are an increasing number of disputes involving SEP, the use of which is essential for 5G and the Internet of Things, etc. The main issues here are whether the patent is essential, and second, whether the license terms offered are so-called FRAND terms, fair, reasonable, and non-discriminatory, so that there is no antitrust issue. Typically, large SEP disputes are litigated in courts of major patent jurisdictions, like US, Japan, Korea, Germany, and China. There appears to be no uniform standard of review for SEP, and you may need to go through multiple legal proceedings in multiple jurisdictions only to have inconsistent judgment in the end. With this background, there has been an initiative among the patent agencies of those nations to set up a mechanism for resolving SEP disputes by one single arbitration. The parties would agree after the disputes arise to SEP arbitration. And the Japanese Patent Office has been very active in this initiative, and it supports the International Arbitration Center in Tokyo, IACT, a newly established arbitration center focused on IP arbitration. And interestingly enough, the driving force of IACT includes former IP courts judges from those nations, among others, Judge Landau Rader, former chief judge of the US CASC, Court of Appeals for the Federal District, who is the chair of IACT. The list of arbitrators there also include a number of patent litigation lawyers. Tokyo may be a default venue for IACT SEP arbitration, but it does not necessarily mean that arbitration is seated in Japan or Japanese substantive laws apply to the dispute. It may be the case that the arbitration is seated in New York, which means that the New York courts would have the jurisdiction of setting aside the award, with the substantive governing law being New York, but the venue may be in Tokyo. And there is another IP arbitration and ADR center in Japan, that is the Japan Intellectual Property Arbitration Center, JPAC or JIPAC, which was originally founded by the Japan Patent Attorneys Association and the Japan Federation of Bar Association, and that involves many patent attorneys, benrishi in Japanese, as well as IP lawyers, bengoshi. And the JIPAC also offers the service of issuing the advisory opinion on the technical scope of a patented invention and an invalidation determination to determine whether there are grounds for invalidation of patent. Then the question is whether and how international arbitration lawyers like us could be further involved in those centers or can contribute to this new development. Are we on a different planet, or can we collaborate to make the dispute resolution system work better? It has yet to be answered. Thank you.
Thank you very much for that overview, to Hiroyuki. That was very helpful. And under that framework, Kevin, could you maybe give us a comparative analysis with how things go in the Korean jurisdiction, in Korea, please?
Thank you. Actually, the situation in Korea is very similar to Japan, as the case in other areas. We have a patent, rather than IP High Court, we have patent court specialized in the IP dispute. And we have a same patent registration dispute mechanism, very similar. But what's happening now in Korea is that we had, as you know, we have the experience of the big IP dispute, Samsung Apple dispute, which Tony's firm is actually deeply involved in. And they have that during that dispute, there is more than 50 litigations in different jurisdictions. And they have a fight and inconsistent judgment on different jurisdictions. Then we have, I see the Korean companies now try to agree arbitration in order to solve all the issues together in one jurisdiction. And the Korean court position is, as long as the party's right is disposable by the parties, there is no issue of arbitrability. So I see recently in an IP dispute, although it's a lot of IP dispute is still resolved in a court, particularly in many cases in U.S. court still. But in many arbitration, I see no longer a party is just argue the arbitrability of the IP dispute, because we know that in many cases, particularly when you have arbitration, that means there's some sort of agreement already. So agreement-related dispute mostly disposable by the parties. So I have experience, for example, I'm acting as an emergency arbitrator in a case that is a dispute about design involving 150 different jurisdictions. So the emergency action is required to cover 150 jurisdictions that involve some design on the earphone. And there's a high sales season between Thanksgiving and the Christmas season. Then you have immediate action to take all the actions on 150 different jurisdictions. The only way you solve it is arbitration and emergency arbitrator process. So, and the other thing is in an online dispute, online game dispute, it's quite difficult to tell which jurisdiction is really relevant. There is a litigation in China, litigation in Korea, litigation in Japan, and the arbitration in Singapore under SIAC rule. They're dealing with the same dispute, similar issues, but different context. So rather than I just repeat what Hiroyuki said, what the system in IP dispute within Korea, I would say the current trend in Korea is that we are using more arbitration or the mediation in IP dispute, particularly copyright and the patent or design patent, but not on the trademark. Trademark is quite unique. You have to register, and the particular always have some issue with a competition law. So I didn't see many dispute on the trademark, but the copyright and patent and design dispute, many cases are now coming to the arbitration. Thank you.
Thank you very much, Kevin. I've heard stories about with these online games, there are actually disputes within the universe of the game where people are fighting over who owns an item from the game. And they're trying to find ways to have online dispute resolution to handle these internal issues as well. Okay, now I'd like to move to Singapore, specifically to Brian. Brian, if you could give us historical concerns and overview about how arbitration in Singapore has approached this issue with IP over the years.
All right, thanks, Tony. I'll just speak broadly first from experience. And it's not to say that arbitration and IP are mutually exclusive in the past. There have been lots of arbitrations where elements of IP are in the case. It's just that it's been packaged differently. So, for example, a patent dispute could be packaged as a patent licensing issue, a breach of contract, where the issue is, was there a breach of the contract? And breach of copyright, I'm aware of one case. It's a large case where employees took confidential information as well as designs. And that was packaged as a breach of contract and breach of employment terms rather than breach of contract. The issue is that in the past, there have never been clearly very defined cases for pure, let's say, trademark or copyright or patent infringement per se. So if there is, copyright infringement, our usual recourse in the past was to go to court. And my experience has been that, excuse me, it's these battles are hard fought, they're painful, and at the end of the day, parties don't want to do business with each other. And on reflection, I sometimes think that perhaps parties should have considered mediation. So placeholder, Tony, we should just talk about that a wee bit later on. Mediation or arbitration, because in court, the judge does not get involved until almost when it's going to trial, and it's usually hard fought, before in Singapore, the registrars, whereas in an arbitration, the tribunal gets involved right at the beginning, and being senior arbitrators, they tend to control the parties and the issues much more closely right from the start. So I'm actually quite excited that, more matters, revolving IP and technology could go to arbitration. Now, coming to Singapore, there's nothing in the old Arbitration Act in Singapore that prohibited, or International Arbitration Act that prohibited the arbitration of IP disputes. It's totally, there's no prohibition. The issue has always been, because in traditional litigation in court, the defendant would always take steps to try to revoke the patent or the trademark. And that was a standard, counterattack, so to speak. And clearly a tribunal has no jurisdiction to make any order on a national registry to invalidate a patent or a trademark. Now, the whole focus in Singapore, the Singapore government on IP and arbitration sort of started way back 2013 with what they call the IPOS master plan. And all this is available online at the IPOS website, by the way, and updated in 2017. And it was a comprehensive plan to try to make Singapore a regional IP hub, not only for disputes, but for creation of IP, prosecution of IP, and the protection of IP. And numerous studies were undertaken, and the findings were that IP enforcement is expensive, and I think we all know that, high cost. And they were thinking not necessarily so much of the Samsungs and the Apples, but rather the small creators, the smaller companies, can they afford, you know, to pay for IP enforcement? And the suggestion was for more cost-effective options for dispute resolution. And another comment was the length of trials. I think oftentimes, you know, the shortest that I've done is probably 5 days, and the longest was like 20 days. And so, you know, that adds to the cost. And as Stanley referenced earlier, in 2017, there was a recommendation by the court. There was a working committee of practitioners, courts, and various stakeholders to relook at the whole dispute resolution framework in Singapore. And they came up with a number of recommendations. And the court, you know, was very open, and they did not say this was purely the jurisdiction of the court. They recommended, the working paper, or the working group recommended that there should be clarification as to the arbitration of IP rights in Singapore. And that's what they did. And they made it very clear that it is not against public policy, and Stanley will talk about this, it's not against public policy in Singapore for there to be arbitration of IP rights. The decision, or not the decision, but really they made it clear that essentially arbitration is a private agreement between parties to arbitrate. There's no jurisdiction to bind third parties on the decision, you know, as to whether the IP is valid or not. And the court, or rather the working committee, made various recommendations insofar as the court's concerned. The court is going to be creating a fast track for IP cases. They're going to also, or they've made amendments to the Arbitration Act and the International Arbitration Act to make clear that arbitration is not against public policy, and that specifically calls out that, for example, it is possible to raise the issue of invalidity in an arbitration. And this is sort of the appropriate segue for Stanley to sort of take over and sort of talk about the amendments and the ramifications and experience coming out from that.
That would be great, Stanley. If you give us some overview on that, the recent legislation in Singapore, but also, if may be so bold as to have a second part to this question, could you also give us an overview on the global approach to IP and ADR? Would that be okay?
Absolutely. Thank you, Tony. And thank you,
the mic
Brian.
is all yours, sir.
Thank you so much. Thank you, Brian, and thank you, Tony. Thank you also to the other my fellow panelists for your views. I'm pleased to first of all, I think divide my presentation in two parts. The first really deals with the impact of Singapore's new Intellectual Property Dispute Resolution Act 2019 that was enacted last year. And then secondly, I'd like to spend a bit of time just mentioning the landscape of validity definition of intellectual property rights. And so potentially it is a pretty exhaustive categorization of anything that we can consider to be intellectual property. It states that IPR would be capable of settlement by arbitration as between parties to the IPR dispute. So what it sets the stage for is an inter partes binding effect of any award that emanates from arbitration. In particular, there is a specific language within this act that now says that an IPR dispute is not incapable of settlement by arbitration only because a law of Singapore or elsewhere gives jurisdiction to decide the IPR dispute to a specified entity and does not mention possible settlement of the IPR dispute by arbitration. In other words, I mean, I hope we can all read double negatives, but what it essentially means is you can arbitrate intellectual property disputes, and that does not appear to be any restriction, and any other legislation or provision that specifies adjudication to a specific entity would also be subject to the overall permissibility of arbitration. But the outcome of this award only binds the parties to arbitration. Third party rights are not affected. It cannot affect the status of IP on IP registers. And if I can just digress for a moment, that's always been a traditional concern. To what extent can I, for example, litigate an Indonesian patent registered in Indonesia and make a pronouncement of validity in Singapore, and then in complete disregard of the sovereign act of a state, go to the Indonesian courts and try to enforce that before the courts to say that, on that basis, the patent should cease to exist on the register if a finding of invalidity was made. And that's the sovereignty issue which Tony alluded to in his introduction. Right now, the way to diffuse that argument, because it's very understandable that any enforcement court would take the view that is quintessentially contrary to public policy, because you're trying to circumvent a sovereign act of state to grant a registered IP right. What this new regime contemplates is any finding of invalidity binds the parties only inter se, as between themselves. And the Singapore legislation goes even further to say that the Singapore courts will not decline to enforce an award involving intellectual property rights on the grounds of public policy. So that is interesting in itself, because if you're going to have any adjudication in Singapore that pertains to the enforcement of an award of IP, and you're trying to set aside, for example, an award on invalidity, say of another patent from another country, your public policy argument is not going to be available to you in doing so. So that has an impact on the second part of the discussion that we will have, I suspect, when it comes to the enforcement of rights. Because when you're trying to enforce awards, ultimately when you're advising as counsel where to bring suit, where the seat should be, preliminary questions ultimately end up with, in addition to the decision to take a position on whether it's arbitrable, what are your enforcement prospects in the court in question, in the country in question? And that must be the last question should sometimes be answered first. So I summarized that the position in Singapore in relation to the latest act. Now, in terms of invalidity, currently there are three groups of countries in terms of whether the validity of intellectual property rights are considered to be arbitrable or otherwise. So the first group would be the countries where the validity of IPRs are typically considered to be unarbitrable. There is a statutory prescription or prohibition. So an example would be, for example, the South African position. The Patents Act in Article 18 has such a prohibition. Similarly, if you look at China, the arbitration law of and Article 3.2 in particular, in China also has that prohibition. Not surprisingly, the Unified Patent Court agreement in the European Union also has a prescription against arbitration. Well, for obvious reasons, because you're trying to promote the use of the Unified Patents Court. It can hardly be in their interest to promote arbitration concurrently. So that's the first group where you do see express prohibitions. The second group of countries would be countries similar to Singapore and Hong Kong, where we're beginning to recognize inter partes binding effect of awards that deal with IPR. So they are arbitrable, but only on an inter partes basis. We are not in any way seeking to augment or circumvent any IP register that is still within the sovereign rights of state. But countries like Singapore, Hong Kong, US, which was mentioned by Mr. Hiroyuki, and France and Germany, Portugal, you see that there is an increasing tendency to recognize that the inter partes effect of such awards can carry some traction. Although it may not be, how that emerges is also different. I mean, you may have a situation, for example, where in Singapore and Hong Kong, you have express legislation, which makes the position very clear. But you have certain courts, like in France, for example, you have French decisions where even though they recognize that administrative bodies do adjudicate IP rights, sometimes in the course of a contractual dispute, it's recognized that that is binding on the parties on an inter partes basis, which is why I would put that under an inter partes category, the second group of countries that cover inter partes recognition and binding to an IP award. And the third category would be where IP rights are fully enforceable or recognized to be so. So like under Swiss law, for example, you see that kind of permissibility. Belgium also allows for the full arbitrability of patent disputes, and that's clear. So that sort of summarizes, in my mind, the landscape in the world. Of course, there are other countries who would be happy to learn, but that is where the world divides. So what I think a broad observation, 2 points. The first is that we're seeing less and less skepticism towards the arbitrability of IP rights. A lot of this has built on the work in the past. It's been made clearer by legislation, so that's welcome. And it leads me to the final point I want to make, which is to take the discussion on arbitrability of IP or the arbitration of IP rights out of the preliminary question and focus on other things. I think other considerations would include your place of enforcement. Is it ultimately going to be enforceable when you're trying to adjudicate a foreign patent or design or trademark right that is the subject of arbitration proceedings in the country where the right was initially granted? It is possible, it is very likely that in an infringement proceeding, you will be always dealing with the relevant citers of the intellectual property right would be the law to apply in the context of a territorial infringement. You will never, for example, have a Hong Kong infringement scenario adjudicated according to a patent that was granted in Singapore. It just will not happen because your patent rights are tied to the registers for the territories that they arise from. And so the law of infringement that should apply would always be by reference to that. And the arbitrator would be seized of that. And an arbitrator would try and get the parties to agree to that as the starting premise in the interest of autonomy and agreement. And so that's one aspect in enforcement. Secondly, another consideration is where can you get your best remedies to deal with injunctive relief, for example, which is a very common remedy for intellectual property. So the law of the seat is important there, and also the law of the institution. I mean, do your arbitrators actually have the power to grant interim relief? In Singapore, we can. Under SIAC, we can. And that may make all the difference. Absent that, the question then is whether the legislation of the relevant country supports curator assistance, where you can go to court to apply for curator assistance to support an arbitration that has intellectual property rights at the heart of it. So that's one way of mitigating the remedies and addressing that. And so at the end of the day, at a very practical level, we're really looking at where is it where, in which country will the award of an arbitrator in relation to intellectual property rights be most effective and enforceable, is perhaps the first question to ask. And then the issue of invalidity is best canvassed more in terms of a response or a defense to infringement, because when you do that, you're putting invalidity into issue. You're not asking the arbitrator to make any declaration that a set patent should be removed from a given register, but only that a set patent or registered design or trade should be invalid for the purposes of the arbitration, in which case it will bind the parties on an inter partes basis. So I'll stop there and look forward to questions. Thank you.
Thank you very much. Thank you very much, Stanley. And just to fill in the one more with the blanks, just when we're discussing public policy and when we're discussing validity issues and enforcement issues, this is all under the pretext of the New York Convention as an enforcement tool. I just want to make sure that all the audience is aware of this. Now, I wanted, Brian just raised his hand. So Brian, what did you have to add?
I was actually going to say the same thing, Tony, that just for the audience, they should know that the context in which we're talking about public policy is because in the New York Convention, Article 5(2)(b) states, and I'll read this, is that a state may refuse to enforce an award if doing so would be contrary to the public policy of that state in which enforcement is sought. So that is the overarching context which subsequent legislation in various countries and laws are trying to explain what public policy is, because it's not defined in the New York Convention.
And Hiroyuki and I had an offline discussion on public policy, so I just wanted to turn to him to see if he had anything to add to that as well. Thank you very much for that, Brian. Hiroyuki?
Thank you. Thank you, Tony. Just briefly about one issue on public policy. So suppose there is a very simple license agreement for patent for global market, and there can be a clause which says that the licensee should not challenge the patent, and also there may be a clause which said that in the event that the patent is invalidated, the licensee still needs to pay royalty. So depending upon which jurisdiction, that kind of clause may be found to be in violation of their local law or public policy. But if the agreement has the SIAC arbitration clause and the governing law of the contract to be Singapore law, what jurisdiction's public policy shall apply is one issue. So this is not the place to give definite answer now, but I just wanted to raise the point that as a counsel or an arbitrator, you should always be mindful of that kind of conflict of laws issues so that you won't miss the point. Okay, thank you.
Thank you very much. And Kevin, would you have something to add to that?
Yeah, I just want to add one point. Just say, when you say the public policy, at least the Korean court position is that their public policy is international public policy. So even though something is not actually different from the Korean law, so there is some mandatory nature of the Korean law, does not necessarily means it is against the public policy. So we have very clear court precedent. So unless there's something really against public order, it's like a fundamental public order of society, it can be enforceable in Korea. So actually, it's almost impossible to prove that unless they actually just say two parties have dispute and then just say you want to register somebody's patent in Korea. It's not acceptable because it's have an impact on other parties' right. But in many cases, actually, the dispute is about the contract. Normally, have a contract in it, and have an issue, who pays what, and then one of the preliminary issue, who has the patent right. So, as preliminary issue, who has patent right, that is the between two parties. And whether or not that is arbitrable, not arbitrable on that particular point, under Korean law, still it will not have undermined the public order of the Korean international public policy. So that's why I just say that public policy or the arbitrability is not is quite limited in actual application. Thank you.
Thank you, Kevin. I guess another issue for another discussion would be whether, if we're really dealing with a sovereignty issue as far as validity is concerned, is it really a public policy issue, or is it just an issue of sovereignty? Does the New York Convention have the ability to compel a sovereign to change their system of registration? Stanley, please, I saw you shaking your head, but what do you think about that?
The answer would be no. I think
that's what I was thinking. Yeah,
because you see, and the thing to get around is, I think if I was giving a talk on this 10 years ago, and I think I did, been around for too long.
I'm not surprised, Stanley.
Yeah, thanks, Tony. I think the issue of bringing sovereignty would have been a more relevant point 10 years ago. But I think now the litigants' sophistry has moved to a point where invalidity is now canvassed in a very different way. So I can canvass, for example, patent invalidity as a defense to infringement. So I'm not asking for anything beyond seeking an arbitrator's declaration that the patent, for the purposes of the arbitration is invalid, and therefore a complete answer to an infringement action. So in that being the case, I mean, it takes away the sting, takes away much of the sting, because it doesn't result in any ramification for a national register. The patent continues to exist in the national register in question, and the patent owner can still assert his rights against other parties in that country where the patent right exists. But for the purposes of the arbitration, you're not less likely to invoke public policy, I think, because there's less of an interface. Now, is that to say that there's no impact whatsoever? I think the one thing that we also need to acknowledge as IP arbitration lawyers is that the language that is common, even though there are differences between countries. The knowledge, the common baseline, for example, what your CGK is, your common general knowledge at the application date of a patent, or better known as the state of the art at the time, that's something which most arbitrators will be keen to fix. And the analysis is pretty much common amongst many countries. Prior art, for example, technology that can potentially invalidate because of an absence of novelty or inventive step, those standard criteria would pretty much exist in most jurisdictions of the world. It is a common language which has arisen through the implementation of international treaties and so on. So to that end, I mean, if you do come across very compelling prior art that calls a patent into question, well, then sooner or later, that will probably have a further downstream impact on us. Even though it started between parties in an arbitration. So I think that in a very convoluted way tries to address the issue on how do you deal with public policy.
Not convoluted at all. I think it helps clarify the situation. Thank you very much. And Brian, you had something to add to that?
I was just going to add to what Stanley said, because I think counsel should think, whether suggesting arbitration is a preferred mode, because it can work to the advantage of both parties. For a plaintiff or a claimant, arbitration could resolve the dispute with the other party, the infringer, but it does not put the IP at risk of invalidation. Exactly what Stanley was saying, it does not put the IP at risk. They can, if they lose that case, fine. No one knows anything about it, it's confidential. And they can try their luck elsewhere. But if a patent, if you're going to fight that in open court, you could lose because of prior art, and the whole world knows about it. And so, I think counsel should think insofar as strategy, which is the appropriate venue, arbitration or court. And right now, obviously, this being a SIAC call, I think arbitration is a good way to go.
I will not disagree with that statement. And being that you were discussing elements that you go over when you discuss with a client why they should consider arbitration, be it confidentiality, for example. So in light of that you're raising something that's broad and general to ADR and arbitration, philosophically, how do we approach IP disputes with ADR? Is it a contractual issue or is it something else? When can you give me an instance of when you would recommend ADR over the courts in an IP dispute? And if I could start with Hiroyuki, any views you might have?
Yes, I think the benefit you can obtain from the ADR particular mediation is not only the confidentiality, but also you don't really have to mind the possible public policy issued applicable law, which may be different from jurisdiction to jurisdiction, but you can have one single venue platform to resolve the disputes globally without taking too much time for jurisdiction by jurisdiction exercise. So my sense is that contrary to what people may think about, the more complex the dispute is, the better chance of mediated settlement.
Okay.
That's why the mediation is used, yeah.
Let me just run with that for a second. Before I ask for everyone else's views on this broader philosophical question, let me just zoom in on mediation, especially since Brian told me, he said, Tony, put that off the side for later. And I take what Brian says very seriously. So I would love to hear some of your experiences dealing with mediation as a tool in settling IP disputes. And since, Brian, you raised it about 30, 40 minutes ago, please let us know what you have to say. You're unmuted? Oh, please.
I'm unmuted. I was just looking for a question. Someone did ask in the audience about mediation.
Yes, they did.
And I'm just trying to think now. Yes. I'm just trying to think of my track record insofar as mediation IP disputes. It's kind of like 50-50 right now, to be honest.
Okay.
And I, as an advocate, have historically, it's against my grain to, in the past, to suggest mediation. But these days, particularly in the current situation the world is in, my view is clients should not be spending money litigating. They should be spending their time, building or rebuilding their business. And I'm kind of forcing people to seriously think about mediation. And the good thing is that there are IP mediators. I don't think there are enough. I don't think there are as many IP mediators as there are IP arbitrators. So I think that's an area which needs to be worked on generally.
What about an issue like standard essential patent discussions where you may have upward 20, 30 parties contributing to a patent? Do you see mediation as being a good tool, at least initially, to see where everyone stands, or do you go straight to the advocacy dispute mode? Stanley, first let's stick with you, Brian, and then I'd love to hear what Stanley has to say.
My personal experience of SEPs in the past when I was in-house working on these things is that the clients, involved in SEPs are all really smart people, and they've had enough discussions amongst themselves that mediation is not going to take them much further. It tends to want to go to a decision, and I would say, as I've agreed with my fellow panelists, arbitration is good because you can consolidate all the jurisdictions into one hearing, and you save a heck of a lot of money.
Okay. Stanley, did you have something to add to that?
Yes, I would agree. I mean, I think there are different types of SEPs. I think for the ones which Brian mentioned, and of course with his historical links with Microsoft and the Microsofts of the world and so on, yes, I think arbitration would be a very good way to resolve friend disputes or even fix rates by the agreement of friend parties. Now, for other types of technology and new entrants to the SEP game, this may be a good time to broach the SIAC ARB procedure, because you may want to at least interpose a mediation process to try and see whether, even if you don't achieve an outcome of a negotiated settlement, you can agree to the lines of the fight going into the final arbitration adjudication. I think that's what brings ARBMET up into, makes it very attractive, I think, in the context of IB arbitrations. I mean, one example of ARBMET up example as well. I mean, context of what we're discussing. If there's a patent dispute, and the way the patent invalidity argument is framed is one demanding a revocation of the patent. Well, the mediation process in that arbitration journey can perhaps say, well, why don't you just, because at the end of the day, you just want to carry on business. So why don't you just frame the invalidity argument in terms of a defense, or just to say that you won't infringe an invalid patent, and if that argument is accepted, you have the same outcome. And if the mediation actually resolves that in terms of a practical solution, then I think the parties will be better for it. So I think that's the one thing I would add, and I think the ARBMET up procedure is very useful. Yeah.
Kevin, what are your views, and what is your experience in dealing with mediation as well with these kind of patent disputes?
Yeah, I agree that the ARBMET solution is quite useful, but based on my experience, because in the course of arbitration now become quite popular, the case referred to the mediation for the solution. In case of IP dispute, there is a quite serious dispute on who has right. That issue can be solved by mediation in a creative way. One party needs solution in one area, the other party needs totally different things. So experienced mediator would provide very creative solutions that both parties just happy with that solution. So that is quite useful. And the other thing is, once liability issue was determined, then issue of the money. And the quantum phase is, as you know, the determining the quantum, you need a lot of money to prove your case, and the expert, sorry to the expert, but it's quite expensive exercise. So when you go to the mediation, then the experienced mediator, particularly who has good knowledge about the calculation and the economic sense, have good solution to both parties can accept. So they save a lot of money. And then also there's another solution you can think about is ADR. It's like it's similar to the expert determination. So when you go to the quantum phase, the parties just jointly hire someone, an expert who just review the case and provide his opinion. So opinion is not binding, but as long as the opinion can be used for on the further dispute, like they are allowed to use that in arbitration. I see many occasions the parties just accept because it's quite persuasive evidence to prove the case. So expert determination can be utilized in the IP dispute in case of quantum. And in case of the liability itself, if you have a very experienced mediator, you have very creative solution. Thank you.
Thank you, Kevin. And let's build on that. And I'd like to ask you a question actually based on something submitted to the audience. And that's first part of the question is, how often would you say you encounter dispute resolution clauses that call for arbitration versus courts? And secondly, do you have experience with cases in which the dispute resolution clause itself may not call for arbitration, maybe calls for litigation, but the parties get together and say, you know what, for all the reasons that this panel just discussed today, why not move this to arbitration? Have you ever encountered that? I'd like to start with you. So the two-part question, what percentage, I know if you're doing solely ADR, you might be seeing a lot more ADR clauses, arbitration clauses, but what percentage of IP cases out there do you think start off with arbitration clauses? And part two is, have you been in a position where you're able to move the dispute resolution to arbitration, even though the clause did not state that? Please.
I think it's difficult to quantify the percentage because it really depends upon the types of the cases, right? if the dispute arises in connection with pre-existing agreements which have arbitration clause, then to the extent that the arbitration clause can be broad enough, then you may need to go to arbitration. And in the case of SEP arbitration, as I explained, the reality is that there may be no pre-existing agreement between the parties, but just because the parties want to have one-shot solution of what would otherwise needs to go to multiple jurisdiction for inconsistent outcome, they agree after the dispute arises to the arbitration. So maybe the answer depends upon the types of the dispute, right?
Does anybody, by show of hands, have any of you dealt with a situation where an IP dispute did not specify arbitration, but you were able to move it in that direction? Move it from a court clause? No? Okay. I've only done that once when it was a commercial situation, not an IP situation, but that's good to know. One more question from the audience is, early on, Stanley had mentioned that trademarks are rarely arbitrated because of sovereignty issues there as well. The questioner asked, have there been any situations that you may have experience with where a trademark-related matter was arbitrated?
Trademark-related matters are less the subject of arbitration. My own experience would suggest that, first of all, I think they're easier matters to settle without the need for even progress to court. But secondly, you find that trademark litigants are more anxious to have their rights vindicated before national courts. And as such, you may not see a prevalence of arbitration. Now, that said, I've actually mediated a dispute involving a trademark brand spanning multiple countries, 10 to 15, and also involving one party mediating by video conference, which is also interesting. That would be actually a very novel way and a more popular way of using ADR for trademark disputes. I think the thing that I would say to that, to maybe extrapolate a bigger premise, would be for IP rights. It's very common, and certainly the practice in Singapore is we find ourselves appearing as counsel in the face of a dispute that is actually a universal global fight, and you're handling the Singapore piece. I mean, I think a lot of us in this table would have that experience. And the question then is, I mean, the advantage to being a local counsel in that scenario is you get to press your rights for the clients before the Singapore courts. But what sometimes you lose sight of is the overall global objective and also the decisions that are taken in relation to a global fight. And that applies to trademarks as well. One way of promoting arbitration and even mediation would be to say that, look, this may be the forum to resolve all your disputes within a single forum, rather than to go to 15 courts to resolve the dispute in 15 countries. And so I think with trademark rights, that would also be archetypally what you want to promote by arbitration. So I'm still reasonably optimistic, and I think more and more people will come around to that.
Okay. Well, we have 5 minutes left right now, so I was wondering if you have anything you'd like to get out before the end of the panel, about 30 seconds or a minute per speaker. Brian, can we start with you? Is there anything that's been an earworm or something that you want to let out about this topic?
I was just going to answer one question, and it says, would an alleged IP infringer have to agree to arbitration order for infringement to be arbitrated? And yes, I mean, obviously, we all know arbitration is a private agreement between parties, so you do need the express consent of the alleged infringer. How would that be achieved? I guess for all the reasons we talked about: speed, cost, confidentiality. And right. I was going to say, if you're enforcing your IP and you think your IP may be a little weak, arbitration is a good place to do a private test run, just to see if your IP is going to stand up or not before you more broadly try to enforce it.
Tied in with our discussion before about whether or not any of us have been in a situation where we're able to convince someone to go to arbitration. Kevin, any last minute contribution on your part?
Yes, I see, you know, for the, and practically as for the enforcement purpose, the IP dispute is much preferred to be arbitrated. IP issue normally involves some developing countries, or some countries have some difficulty to enforce it. So when you have a court judgment in one country, it's extremely difficult to enforce it in other country. And then it's also equally difficult to pursue the claim in the litigation in that country is even more challenging. So still the arbitration globally, relatively speaking, is easier to enforce it, and you have good chance of enforce it, and you can enforce it in other jurisdictions as well. So for example, in the as I told you, online game dispute, which is a big issue in Korea. The online game dispute is, I think that almost every case, the contract stipulate arbitration rather than litigation because they already have bad experience. And because you have to deal with many other countries. And in a trademark issue, as I told you, trademark is still very much like litigated, but exactly speaking, trademark is once the agency refuses to register your trademark, then you already have a problem. It took a long time to fix it. So rather than going to litigation, actually the agency issue, in order to solve that party's relationship, it's better to arbitrate. The notion, people just think that the trademark is not friendly with the arbitration, but in reality, yes, you have to go with the agency issue. That agency is a separate thing. But if you think about the litigation versus arbitration, still arbitration is a good solution to solve overall the problem. So that's why I see that more arbitration involving IP dispute. Thank you.
Stanley, very quickly, anything to add? Stanley?
Yes, I think I would just ask. I mean, I would just float this in terms of a final remark that I think it's time to consider. You know, I mean, countries should actually consider having another diplomatic treaty that harmonizes IP dispute resolution in the context of arbitration, in the context of the ARB procedure, and also in the context of recognizing and enforcing the judgments of international commercial courts, which may be set up in different countries that may not have any domestic or national connections. I think it's time to, you know, in a more charitable environment, to consider that, because I think it will make a real difference to dispute resolution in intellectual property.
Thank you. Hiroyuki, anything to add?
Yes, when you read the Japanese government guidelines for the SEP negotiations, you will find the reference to ADR. That is, if a party makes an offer for ADR as a way for settlement, then the other party who would refuse such ADR may be viewed as not acting in good faith, right? So I think the Japanese government, the Japanese Patent Office, is very much interested in ADR on IP dispute. But we need to be very careful in the pattern of way of thinking of the patent agency. And this is an area where not only the arbitration legislation agency is very eager to promote, but the patent agency is eager to promote, but they are very careful about the situation where the two parties agree to settle with the secret deal to preserve the monopoly on the patent, which would otherwise be invalidated so that everybody can use, because it is within the public domain technology. So I think it's okay for us to say that, oh, IP arbitration should be promoted because it's good for efficient solution, one-time resolution for global disputes. But maybe we should not too much emphasize that, okay, by using the ADR, you can secretly achieve the parties' benefit by excluding the other people from use of the patent. That's my cautious comments.
Well, that's a good note to end on. This is not panacea. This is not a world cure. We're just here discussing how we can improve things, and that ties in also to what Stanley was saying about the need possibly of another harmonizing document. I'm hoping someone from WIPO or UNCITRAL is watching this today and will be inspired by our discussion. I again want to repeat, it was an honor to mediate such an esteemed panel, and to thank SIAC for all they've done. For all the audience, this is a part of a continuing series that SIAC is putting on. Please keep watching your inboxes to see what other future wonderful events they have to offer. And thank you to the panelists, and thank you to the audience, and thank you to SIAC. Thanks all. Have a great evening or morning, regardless of where you are, and stay safe in these crazy, crazy times. Thank you very much, everyone. Thank you.
Thank you.
Thank you.